Good evening to everyone, and thank you for joining us for another edition of Family Matters with Judge Philip Smith, hosted by yours truly, Stephanie Williams. Thank you for indulging us this evening. I have the pleasure to serve as the special master for Judge Philip Smith in the Fourth Circuit Court here in Davidson County, and we are excited to bring to you another episode of Family Matters with Judge Phil Smith. Before we get started, I just want to make one acknowledgement for all of my friends out there. I'm having a really bad hair day today, and I just haven't been able to get that together. So please excuse me on that note. I will do better next time, I promise. But it was raining this morning, and I've just been really busy doing some things. And so it's just a bad hair day. What can I say? So having said that, I want to jump in to say good evening to Judge Smith and talk about how there may be a picture circulating around on social media with Judge Smith having a little more hair than we typically see him with. Tell us a little bit about that.
Well, before I do, I want to recognize my good friend and my colleague and fellow McGavitt graduate, all three, Judge Amanda McClendon, who's on the call, and Amanda, Judge McClendon, welcome.
Thank you. Thank you for doing these series. It keeps me up to date on things.
Well, you know, we try. Stephanie keeps me up to date on things. Getting back to the photograph.
Yeah.
Yes, Judge Fishburne and I we co-officiated a wedding this weekend for a longtime friend of Judge Fishburne's and one of my students I had for two classes. And she is now working as an attorney with Rose Palermo, Michelle Marshall, if y'all know her, or she goes by Michelle Pye sometimes too. But we did the wedding, and we did it in our robes and barrister wigs. So I did have a lot of hair, that faux hair, I guess. And I will tell you, we were in the sun outside. While it was a beautiful day, those wigs are very, very warm when you put them on. And then you throw a black robe on top of that. It was a little warm, but it was a blast. We had a great time. It was at the Bobby Hotel up on one of the outdoor patios, I think on the 6th, 7th, 8th floor or whatever. But we had a great time. So thank you for asking me. If you see that and that picture, just know, yes, that is me. Of course, I know none of you would be surprised to see me in a barrister's wig.
Thank you so much for making that explanation to everyone. And I'm sure people will now be out there looking on Facebook and social media to find this picture of you. And I'm sure we might see it again at some point.
Friends, my close friends have already gotten a hold of it. And yes, there were a few comments on that.
I'm certain there were.
Yes.
So you kicked off your campaign last month.
Yes, we had our campaign kickoff on the 24th. I thought it was a great success. Many of the folks that are here on this Zoom event were present, and I appreciate everybody that came. It was just a resounding success, and look forward to getting more involved in the campaign and moving forward. And hopefully I won't have opposition, but who knows, I may. But we're getting ready for it. And but let me say, you're always worried at these events, first, is anybody going to show up? So when that first person walked in, it's a little bit of a relief, but we had a good crowd, and like I say, it was a success. So thank you, everyone.
Absolutely. It was a great event. I enjoyed every minute of it. And we're just looking forward to continuing to do what we do. And
that's right.
And stay in Fourth Circuit Court.
And for everybody on here, we have made some changes due to the increased number in the COVID cases. We are doing the Monday docket, the child support docket. We are doing that by Zoom. We're doing ID divorces, irreconcilable differences divorces by Bridgeline. We're doing defaults by Zoom. Our contested cases, we are having to do live. There's just really no way around that. And our Thursday docket, we're doing live also. But beginning Friday, which is going to be a very busy day, the motion docket will be by Zoom. So keep that in mind. It's going to be a long day, but it will be by Zoom. So if you want to sit at home and drink a cup of coffee and sit in your pajamas, that's fine too, except for all of the men need to have neckties on.
All right. Yeah, it'll be by Zoom. And for those of you that are looking for information on how to log in and what time your case will be heard, please know that we post our staggered motion docket every week on the Circuit Court Clerk's website. So if you go to the website for Ricky Rooker, the Circuit Court Clerk, and click on the tab that says Circuit and scroll down, you'll see different line items that have for each court, like First Circuit, Second Circuit, Third, and you will find Fourth Circuit Court. And then under Fourth Circuit Court, you will look for the staggered motion docket. And that will have all the information you need in terms of what to do, the link to log in, and the time for your case, as well as instructions and what to expect. So we're looking forward to it. There is a pretty big docket, but we will get through it. It'll be just fine. Yeah.
Well, I just saw Ms. Lorraine Wade, her picture pop up. It looks like she's in a car. Lorraine, I hope you were not driving. Well, I can't.
Muted.
Couldn't respond. I like this mute button on Lorraine. I do. I like that.
Oh yeah, no, I'm in my garage.
Oh, okay. All right. Well, she's calling from her car in her garage.
In my garage. See?
In your garage. Yes, I like that. I like that. This weekend, we got out in Saturday morning and went to a 9/11 event along with Judge McClendon, Judge Jones. Let's see who else was there. Chancellor Moskal, Chancellor Martin, Judge. Who else was there, Amanda? Judge Dalton was there. Judge Smith was there. It was a wonderful event. We started at the courthouse for a moment of silence at the time the first plane hit the World Trade Center. We then walked down to 2nd Avenue and marched down underneath this huge American flag over Broadway, which kind of gave you chills to walk under. And then over to the plaza outside the Skimmerhorn. And I have to say, it was a very inspiring event. It was, it was to the point, these people the fire department and the police department had worked a long time in putting it together. They did a great job. And I will just follow up by saying, we can never forget what happened on September the 11th. We can never forget. And it is an important day, and we always need to remember the big anniversaries of September the 11th.
Yeah, I think September 11th is one of those things, like everybody remembers where they were on that day and what was going on. And you really don't forget that, right? It's just one of those events. I remember at that time I commuted to and from Nashville and Knoxville going to law school. And I was on my way to Knoxville when somebody called me or something, or maybe I heard it on the radio, but I remember being on that trip to Knoxville, hearing about it that day. So absolutely.
It is something that I will remember until my memory no longer is functioning the way it should, or until they put me in the ground or run me into, or Judge Gail Robinson runs me through the burners because I'm going to be cremated.
Yeah, he will.
Are we ready at this point?
We're ready. Let's go on and get started. So tonight we're talking about division of property. And I think we might want to really start off talking about classifying.
Yes.
I think that's our first step before we divide property is just classification and classifying. So talk to us a little bit about classifying property and why that's important and what that is.
Well, actually, that's the first thing I do when I'm working on a decision and I get to the point of dividing property. I want to classify what is separate and what is marital. And I'm working on an opinion right now where there's virtually no separate property. Party's been married for over 30 years. So, they didn't have a lot that they brought into the marriage. And so everything they've accumulated is marital. But the reason you want to classify it is because only marital property the court can divide. It cannot divide separate property. It can be considered in an award of alimony. And any increase in value of separate property, well, I say some increases in the value of separate property may become marital if the statute's complied with. But the classification is really, really important. And it can affect the division because one of the considerations under 36(4)(121) is the separate property of the parties. And like I say, it's easy to get it on out of the way, classify it, list it, and kind of put it over here to the side and focus on the marital property. But that's the first thing you do is classify the property. Tennessee is a dual property state. We're not a community property state. So our separate property always retains its identity.
And tell us a little bit about what is the definition of separate property, or what is considered to be separate property versus marital property.
Well, it can be anything that you bring into the marriage. Say you had an investment account in your name, and you have it and have not changed it and keep it separate. That's your separate property coming into the marriage. Maybe it is an automobile that's been paid off that you bring into the marriage. That's your separate property. It could be a home. But something that you may get later in a marriage is an inheritance. An inheritance is your separate property. You don't always get it at the beginning. In fact, you rarely get it at the beginning. You get it during the marriage, but that's your separate property. And to really make sure that the separate property retains its identity, you don't mix any marital property in with the separate property. And what I mean by that is, it's talking about that investment account. If you have that investment account and it's worth $100,000 on the day of your marriage, and you can trace it back to that at the time of the divorce, well, that $100,000 is your separate property. Now, there's two paths that can be taken with that investment account. If you continue to put earned income into that separate property, then it could be commingled, or the increase in value due to the contributions of the marital property could be deemed marital property. But if you take it and you just let it ride the market, you don't do anything, put anything in it, really advise your broker, take any active steps to improve the value, then you're probably going to retain that property as your own separate property. And that would include any increase on that due to the market.
So it would be advisable to a client, let's say, maybe who was getting some premarital advice, for any accounts or investment accounts that they may have going into the marriage, to allow those to just grow on their own through the market or otherwise, don't contribute to that. They can still open up another account and then just begin contributing to that. So it's very clear that that's separate, the difference between the separate and marital property as it relates to those two investment accounts. Is that a fair statement?
That's correct. Of course, I think the best way, if you want to preserve your separate assets, particularly those that are generating income, consider a prenuptial agreement.
Yeah. So let's talk a little bit about transmutation. I had a student, we dealt with the division of property in class, I think last week maybe. And I had a student that was asking for a friend. What effect would putting a spouse on a deed to a home would have as it relates to taking something that was separate and making it marital or transmuting it. So he, even though he was asking for a friend, he seemed really disappointed at my answer to him, like it was personal to him. But let's talk a little bit about transmutation.
Well, and in talking about transmutation, it is like commingling. They're both judicially created doctrines. Transmutation generally applies to real property. Commingling generally applies to monetary accounts. But what it is where you treat that property as marital property. Okay, your actions create an intent that you want or you intend to, view that as marital property. Putting your name on the deed of, putting your spouse's name on the deed of your separate property raises a presumption that you intend for that real property to be marital. Now, that is a presumption. I've rarely seen that ever challenged, and I've never seen it rebutted, but it is a presumption. So there may be a circumstance where you can rebut that. So always keep that in mind. But that is a presumption that is in fact marital property, the entire equity in the real property.
So let's talk about marital property a little bit. Clearly, anything acquired during the marriage would be something that the court would at least start off classifying as marital property to look at how to divide. Let's talk about the increased value of a separate, something that was a separate asset or separate property, the increased value that took place during the marriage. What's important to the court in terms of looking at something like that and the valuation of it? How does the court value that?
Yeah, and just take real property, for instance. You have a separate parcel of real property, say it's an improved, say it's a home. You've got this separate parcel. You own it prior to the marriage. You're paying off your mortgage on it. And you can, you're going to continue to pay off the mortgage during the marriage with earned income. For the party
Okay, folks, we're trying to get, internet system apparently went down around the city some, so we're trying to get Phil logged back in right now.
Okay, can anyone hear me?
I can,
I
Yeah.
can.
I can.
Now,
but you did disappear.
I
You're gone
think
again.
the internet system went down. Stephanie's internet went down. She's on a complete opposite side of the city than I am. So Judge Smith, go ahead and keep talking.
I forgot what I was talking about. Substantial increase to the appreciation or preservation. Okay, it is incumbent on the party claiming an interest to establish that they have that interest. Now, when you're dealing with real property, you got to you've got to actually look at it from a standpoint of that value at the time of the marriage that accumulated prior to the marriage is separate property. And you have to establish what that baseline is. I call it the Cutsinger baseline. And Cutsinger versus Cutsinger is the case that really establishes that you have to do this. You have to really have two appraisals done on the real property. One, you have to get the appraiser to do an appraisal as the value existed at the time of the marriage. And then you've got to get them to do a current appraisal. Now, this will show you what the increase in value is, okay? The difference in the two appraisals. Remember, what the value was at the time of the marriage is going to be separate property. Really can't change that unless something is, that's the non-title spouse is added to the deed after the marriage. So you've got this value from the time of the marriage until current, but that's not the end of it. Okay. That's going to show you the increase in value, but to establish the entire equity, you got to see what the debt was owed on the real property at the time versus what the debt is present day, because that reduction in debt is going to expand the equity. And that equity is going to be what the court can divide. The separate property, the value that accrued prior to the marriage, the court can't touch. But you want to make sure to include that reduction in debt. And a lot of lawyers forget to do that. Mm-hmm. But in a longer term marriage, there's going to be a bigger reduction in debt that is going to increase the equity. So don't just look at the increase in value, look at the reduction in debt also.
So even when we talk about that increased value, and we know that will at least be part of the marital pot, how do you look at dividing that? Because we do know that we've got to show that the spouse, let's say, that is not on the title, has to have made a substantial contribution to that asset. And so what does that mean? What does that look like? How do you gauge that?
Well, that's kind of a case by case analysis. You're going to, different cases may justify a disproportionate division of that equity. And it just really depends. In my mind, I kind of start with 50-50 and look and see why shouldn't I divide it 50-50. There are other things you look at. You may want to give more of the equity in the house to one side because one party's getting more of a marital retirement account, a 401k. Of course, we all know that's not a dollar for dollar exchange. but you may want to use it to offset. But there are lots of reasons why you may want to make a disproportionate division.
And when you say it's not a dollar for dollar exchange, because you're talking about a 401k account versus the interest in a house, let's explore that a little bit more, because I think that's important for attorneys to know, that it's really helpful to try to, you know, compare apples to apples and oranges to oranges when you're dividing things. Otherwise, you can really make a division inequitable when you don't look at, when you kind of divide things that are different.
Well, one of the factors under 364121 is one of the factors you consider when dividing property is tax consequences. A 401k, 403b, things of that nature. If you pull money out, you're not going to get the full amount. Say your 401k shows that it's worth $100,000 and you want access to the $100,000. There's going to be probably a penalty and there's going to be tax consequences. And that could be as high as 40%, you know, the penalty and tax consequences together. So, you know, a dollar for dollar exchange, you would have to discount that, the value of that 401k that one party is getting, in order to discount it significantly in order to equal what the amount of equity to match the equity that the person is receiving from the increase in value of the marital residence.
So, go ahead.
It's tough. That's something you always have to remember when you're negotiating a case. In that situation, probably the best thing to do is if the property is being sold, go ahead and divide the equity 50-50, but go ahead and divide the retirement account 50-50. So everybody is sharing in the tax burden associated with the retirement account.
Yeah. Now that's definitely what I seek to encourage people to do when they're working in judicial settlement conferences. One of the questions that we have this evening is, if a spouse has moved out of the residence and the remaining spouse stays and covers the mortgage for years before filing divorce, is there still a strong presumption that 50-50 equity is fair and equitable, or does the remaining spouse get a bigger chunk?
Well, there again, it depends. Very lawyerly like answer. You know, what has the other spouse been doing? Have they been contributing money to that spouse in order to pay that note? Have they been accumulating a retirement account, a 401k or 403b, IRA, SEPs, whatever? Have they been accumulating that in lieu of contributing to the upkeep of the home? You know, if the court is going to look at that retirement account as marital property, which it would be, and divide it 50-50, then you got to think, why wouldn't the equity in the house that's accumulated since the other party moved out, why wouldn't that be divided 50-50?
Now,
a lot of different things you look at.
So what if the house was really the only asset? Let's take any other assets out of play, and the house is really the only other asset, and the spouse that is no longer living in the residence has not done anything to support, they have no children, and that spouse that has left the residence has done nothing to support the spouse that has remained in the residence.
Then you may want to consider a disproportionate division. And you just have to look at the factors set forth in 364121 and, you know, come up with what you think is fair and equitable. But that may be an appropriate situation for a disproportionate division.
Now, when you're making a ruling on a case that deals with the division of property, obviously, and alimony, what do you do first? Do you divide property or you determine alimony?
Well, case law says we're supposed to divide property first. And if you think about it, there's a good policy behind that. What if the parties own a lot of rental property and those various parcels of rental property are generating income? maybe you can divide that rental property in a way that avoids the need for alimony since they're income producing. So, you always want to divide the property first and consider the income producing property. And if it's divisible, then go ahead and divide it. But, the thought is you want to try to divide property in a way to avoid an award of alimony.
Now, another question, which is a really good one, it actually came up in a case recently that I was aware of. While the court may be unable to access a spendthrift trust that favors one spouse, does the court nevertheless consider the assets held in the trust in dividing property?
Certainly. I mean, one of the factors that you can consider is the separate property of a spouse in dividing the marital property. Now, what do you look at in that situation? You look at, does that spouse have access to that trust? Is that trust held up or controlled by a trustee? And are there contingencies on that trust that have to be triggered before the spouse can receive funds from that? You look at all of that, and it could be a situation where if it is an income producing trust and it's regularly produces income, either monthly, quarterly, or whatever, then that can really affect the division of property and certainly affect an alimony award.
And we do have a question that just came in, and for all of you out there, feel free to put questions in the chat. What about a discretionary trust? Would that make a difference for you?
It could, yeah, absolutely. You want to look at whether that money whether that spouse has access to that money, either a monthly benefit coming out, a monthly distribution, quarterly distribution, whether they can access it for various reasons, including emergencies. How difficult is it to get at that money?
Let's talk a little bit about debt. What does the court look at when dividing up debt?
Well, debt's not provided for in the statute. Years ago, when I first understood that, I thought, wow, it's really kind of weird. We have this statute that, addresses grounds, alimony, division of property, attorney's fees, but we don't have a statute that deals with debts. So, we don't have any guidance statutorily. Our guidance is really common law from the various case law that has come down. And, you have to look at what was that debt incurred for? Is it a student debt? Is it for a student loan? And generally, student loans will follow the person that incurred the loan, particularly if they benefited from the loan. Let's assume there was a debt incurred to go to medical school, and the person that incurred the debt is now practicing medicine, making a lot of money. They got the benefit of that. So why shouldn't they be responsible for that debt? Did the debt go to the benefit of the family? Credit cards or not debit cards, but credit cards. What if you're charging groceries for the family on your credit card? What if you're charging cleaning supplies, gasoline for the car? All of that may be debt related to the family. Mm-hmm. So it may be subject to division, or maybe you want to attribute more of the debt to the person with the lion's share of the income. These are all considerations that you make. Now, if it is debt that, say, a husband has incurred taking trips with his paramour or buying jewelry for his paramour, that's not one that you would really consider dividing. In fact, that may actually constitute dissipation. But that's how you have to look at debt. And you also have to look at who has the best ability to pay the debt. That's really important. So, there's no cut and dry answer on debt other than to just look at what the debt was incurred for and did it go to the benefit of the family.
What are some of the common mistakes lawyers make when they are making proposals as it relates to division of property or arguing their position on that? What do you find that some of the most common mistakes are that lawyers make in that area?
One of the most common mistakes that lawyers make, particularly when debt's being paid with a credit card, you have to pay that credit card off, okay? And they'll show the amount that is going to pay the credit card off, but they're not showing what the debt was incurred for on the credit card. And then the next thing you know, there's $400 over here for groceries, $200 for minor children's clothing or that spouse's clothing. Maybe they're paying their electric bill on a credit card, and they're showing a separate amount for the electric bill. This is double dipping. You have to carve it out. You have to make sure if you're going to include that payment, that monthly payment, if it's going to pay for other debts that you have listed on your income and expense statement, you got to be very careful because, like I say, that is double dipping. That's an old trick that lawyers have used for years. I don't think they do it purposely now, but I think they just mistakenly think, okay, this is the credit card amount that they have to pay, so I'm going to include it on the income and expense statement. They need to dig further with their client. What do you put on the credit card monthly?
Anything else that you can think of that you see with lawyers and making common mistakes in this area?
Well, I mean, I've talked about this before. Really inflating their need. Not a good thing to do. Income and expense statements are submitted under oath. Statute says we can decide pending lighting matters on sworn income and expense statements. And when it's inflated, you're asking for more than the debt, than the obligations of the party. And I understand why, I do. But the problem is, when you get up there and you really overinflate, it kind of creates a credibility issue. And again, probably on income and expense statements, one of the most important things in the early stages when you're going for pending lighting support, but it's probably the most unprepared document that you may have. If you should be spending a lot of time on it, you should be looking at averages of electric bills, water bills. You should be looking at averages for 6 months to a year and not just guessing what those amounts should be.
So when you're looking at, let's say, doing a ruling in a contested case and you're dividing up a marital estate that has assets, let's say there's a home that's going to be sold. I think, well, let me ask this question first, now that I think about it. What is your position on a marital residence in terms of if it is a contested case, ordering that it be sold versus allowing someone to maintain it or be awarded to one of the parties? Like, do you have a preference? What do you look at when you're determining what you're going to do with the disposition of that asset?
My preference is to sell it. And the reason is it cuts that financial tie. A lot of times houses are purchased using two incomes. And that's okay. People do that. That's fine. But they may not have the ability to buy out the other party. And so one party's receiving the home, but both parties are still on the mortgage. And what's going to happen later on when the other party wants to go purchase a piece of real property on their own, and the other side's been unable or, declined to refinance? Well, they're not going to be able to purchase, a new piece of real property because they've got this debt showing on the other home. You got people sometimes that both parties want the house, and you get into a dispute as to the value of the home. This is what the appraiser says the value is. Well, right now we're in a hot market. People are actually offering to pay more than the listing price, and they get into bidding wars on this. So, it may not be an accurate appraisal. What the property will bring on the market is the best way to ascertain the value. So, unless it's an extraordinary circumstance, I generally do not want to award it to one party or the other. My first inclination. Now, I do on occasion, particularly in your big money cases, but in your typical run-of-the-mill working class type cases, probably not going to have the ability to buy the other party out if it is a medium length or long-term marriage. It's just probably not going to exist. And you
Certainly,
can't get to the other side.
Certainly, if somebody wants to take the position that they want to be awarded the house, they would definitely need to show the court very clearly and convincingly that they have the ability to buy the other spouse out, is what I would think, and or refinance to get the other spouse off that mortgage.
Yeah, and right now in this market today, you're going to need to get pre-approval on that if you can. But also in that market today, is that appraisal really an accurate snapshot of the value? I mean, some of these some of these homes are drawing, getting 30, 40, 50, 100, $200,000 over listing price. And, it's great to be in a market like this, I guess, if you're selling.
If you're selling, yeah.
If you sell, where are you going to go?
Yeah, you got to have somewhere to go.
That's right. That's right.
If you are doing a ruling on a marital estate and you've got real property that has equity in it and you've got debts, joint debts, are you more apt to order to sell the real property, which we just talked about, and first pay off these debts prior to dividing any money, or would you handle those separately, if that makes sense?
It's on a case-by-case basis, but my first thought in that situation is always, let's pay off the debt. What does that do? It alleviates the need or lessens the need for alimony if alimony is in play. But two, it really helps the parties start over new. They're starting over financially on their own. It really helps them to be able to start off with a clean slate, so to speak. So, case by case analysis, but those are things that I really want to look at and consider, because, if a lot of times, if there's not a lot of equity, but there's some equity, and, there's enough to pay off the debts in each party to get some of the money, if I just give it to each party, after they get the money, their bankruptcy is always a possibility. So why not go ahead and pay those debts off and let the parties start with a clean slate?
And so, speaking of bankruptcy, how does a bankruptcy, either prior to the filing of a divorce or during the course of a divorce before it's final, impact what the court can do?
Well, first of all, it really kind of depends on what the bankruptcy is. Let's take a Chapter 7, for example, and even a 13, but a Chapter 7 that is filed during the divorce will really stop the division of property by the court in its tracks. There's that automatic stay that issues. And it's frustrating when it does issue, but when it issues, I can't really do anything at that point until that automatic stay is lifted. Now, most of the time, the bankruptcy judges will, if you file your motion, explain, and they'll lift the automatic stay either entirely or partially. With a Chapter 13, you tend to get specific parts of the marital estate affected, maybe the home, maybe an automobile, things of that nature. It's always better to get an automatic stay. The automatic stay, however, does not apply to enforcement of child support or the enforcement of alimony. So, that doesn't stop that. Used to, back when we had the old N. Ray Calhoun and Ray Fitzgerald cases, it used to, but it doesn't anymore. Support issues are still enforceable regardless of the issuance of the automatic stay.
And so if someone, let's say, has that situation come up, either where the bankruptcy has been filed prior to the divorce or during the divorce, and so the automatic stay kicks in and the court's unable to do anything with dividing up assets and debts, would the court consider, let's say it's a Chapter 5 bankruptcy, Chapter 13 bankruptcy, in which the reason I was thinking 5 is because they normally are in 5-year or 7-year, I guess, terms. But and so the bankruptcy is in effect until the 5 or the 7 years, whatever the period of time that the debtor is in the Chapter 13 bankruptcy paying debts. Would the court consider divorcing the parties and then reserving the allocation or the division of the marital assets and marital debts until such time that the bankruptcy case has concluded?
Well, no, there are ways to deal with that. One, particularly a Chapter 13 payment, is usually a pretty constant payment. So you can consider that, particularly if alimony is involved. It doesn't affect child support, obviously. But the quick answer to your question is probably not. And the reason is you don't have a final order. When I just grant a divorce on an interlocutory basis, that is not a final order. People don't understand the difference between an interlocutory order and a final order. So what are they going to do? They're going to go out and get remarried. Okay. It's everything's all well and good until we have to deal with that debt. And, we may have to do something that upsets one of the parties. Well, they take it up on appeal. Again, not a final order. What if the Court of Appeals sets the whole thing aside? Here they are in a bigamy situation. But no, Judge Robinson and I take the position that we have to do it all at one time, and absent extraordinary circumstances. And every time I have done that as a judge, which is only a handful, it's come back to bite me. And I just have decided that absent very extraordinary circumstances, we're going to do it all at one time.
So what I'd like to do next, after going through one more thing with you, is we have a little extra time to open the floor up to people to turn on their audio and turn on their video if there's anything they want to share or a question that they want to ask. But before we do that, I want to talk about our next month's edition of Family Matters with Phil Smith, because we've got a real treat for our participants, our viewers on that. And so I'd like for you to share what we're doing next month.
Well, October is Domestic Violence Month. And, we've seen a lot of press about domestic violence related homicides in the last several months. And we've got a problem with domestic violence in not only Middle Tennessee and Davidson County, but in the entire state. So I had a seminar scheduled back in July dealing with domestic violence, that was going to cover kind of the whole range of domestic violence. The problem is the numbers got up. We didn't want to get everybody over in the Burt's Jury Assembly Room and kind of packed in. And so what we've done is we've postponed that until November. But next month, I'm going to have a special guest, my good friend, Judge Allegra Walker. She and I are going to talk about domestic violence. It is going to be a collaborative event with the Women's Political Caucus, Women's Political Collaborative. Joyce, forgive me. And it's going to be an hour of CLE also. So if you join in next month, you'll be able to get CLE hours, at least 1 hour. And the cost is $10 to cover the CLE cost for members of the Women's Political Collaborative, and $25 for non-members. I think it'll be a great program. Again, October is Domestic Violence Prevention Month, and I really look forward to it. Judge Walker and I have spoken several times together. I love working with Judge Walker. Think she is a great jurist, and I will tell you, she is a good friend.
Yeah, she's wonderful. So I think it'll be a lot of fun and very informative and very impactful. So, you know, $10 for non-members of the Women's Political Collaborative, $10 for members of the Women's Political Collaborative, $25 for non-members. You can't beat that for a CLE, and it's the end of the year. And so we just really encourage everyone to get the word out and to join. So we've got some time here, and that's great because I would love for people to show their video and turn on their audio and just kind of give any feedback they'd like to give to us or ask any questions they may have directly. So we're opening up the floor, which we don't always have time to do, but I'm glad that we have time to do that this evening. Is there anybody out there that would like to share or ask a question with the judge? I can't believe with all these attorneys on here, nobody has anything to say or ask. That's pretty odd.
Well,
Can I
I
ask
just saw Lorraine Wade just unmuted.
Different county, so no, there's no conflict here, but what if the parties did their marital separation outside of the lawyers, but they did it, like exchanged over $200,000 and did their exchange while the divorce is pending? Would you consider that in the final hearing? Or would you just
Well-
say the property's already been separated?
Well, no, I think you have to consider it, but that doesn't prevent the court from trying to do something that's fair and equitable, particularly with what's left. But Lorraine, I think there is a crime out there. What is is it a felony for dividing property outside of a, what is it? When you divide property outside of a divorce and then ask the court to enforce it, what is that called? Aggravated stupidity?
I know, me and we don't know what to do, but they separated the property before we could get to court.
Yeah, I think the court has to consider that, but that doesn't prevent the court from, looking at ways to make that division fair and equitable. Is there any liquid funds left? Is there any other property that can be divided to get the adjustment, to make the adjustment so that it is fair and equitable? I think the court's got to look at it and can't just, enforce it absent a marital dissolution agreement where the parties determine among themselves that it's fair and equitable.
All right, any more questions, comments, thoughts? This is your time with the judge.
I have a question. I was wondering about property that's in another country that the parties purchased. How would that come into play?
Well, the court cannot affect the title of real property in another state, certainly not in another country. Is there a way to value it and put a value that we understand on it? And if there is, yes, particularly if there are other parcels or other marital assets where the court can use that value on that property outside the country and offset it against some other assets. So that's, all we can do is consider the value on it. We can't, order it sold on the courthouse steps in another country. While we do have jurisdiction over the parties and we can direct them to sell the property, that's really a tough order to enforce. And so it's always better if you can put a value on it and let the court offset it, offset an asset against that value. Mabel, does that answer your question?
Yes, sir, it does. I just wondered about that. Well, I have a case coming up, and if they don't agree to it, then that would be an issue.
Mm-hmm. Well, that's what I would want to do, is see a value on it, look at the entire marital estate and see where I can offset.
Thank you.
Anybody else? We have 2 minutes. Going once. Going twice.
I'd like to ask a follow-up question on something the judge said about you want to take care of everything at one time when it comes to bankruptcy. Does that mean that divorce will be put off until a certain time, or what does that mean exactly?
Yeah, I mean, in theory, it could be, generally in bankruptcy cases, the stoppage is only for a short period of time until that automatic stay can be lifted. And it may take out an asset for me to divide, but that's okay. We can go ahead and do other things. And it's a short period of time. I have not really had one that I recall where I had to wait for years for the parties to get through bankruptcy.
Well, will they be granted a legal separation, maybe?
Well, remember, on a legal separation, everything has to be agreed to in a legal separation.
All right. Well, thank you again for joining us tonight, everyone. And thank you, Judge Smith, for imparting your infinite wisdom on us yet another evening. We appreciate
Steph,
that.
thank you. And I love doing this. I love doing it. So
Yeah.
thank you, everyone that turned out tonight. And hopefully we'll see you next month. And when Judge Walker's here.
We'll see you next month, the third Wednesday at 6 p.m. Check your email for updates and links to join us. Thank you. Everyone have a great evening. Good night.
Thank you.
Thank you.